want to, what do you want to call first?
Let's start with Mr. Del Toro.
All right. All right, so we're on the record in docket 2402160. That is People of the State of Michigan versus Juan Del Toro. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Abbott, representing Juan Del Toro. He's standing to my right.
And sir, you are Juan Del Toro, is that correct? Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to count 2 of the complaint. Upon successful plea and sentencing, count 1 would be dismissed. There is no objection from the people to 7694A status should the defendant be eligible, and there is a sentencing agreement to no further upfront jail.
There's no objection to some, did you say HYTA?
7694A.
Status, if available, if eligible, and Killebrew of no upfront jail. Is that a fair statement, Mr. Abbott?
Yes, it is. May I approach?
You may. All right, and so, Mr. Abbott, may I inquire of your client of his advice of rights, and for the record, you've just provided an advice of rights on this file and to the court. Is that correct?
Yes, Your Honor.
All right. All right. So, Mr. Del Toro, you've gone through the 12 rights listed on the advice of rights and signed the bottom. Is that correct?
Right.
I'll go through the main rights with you that you'll be giving up if you plead guilty to count 2, which would be the count 2 is the domestic violence count. You understand you have a right to a preliminary examination. You have a right to a trial on domestic violence count 2. And the ultimate penalty in that case is 93 days under $500. Do you understand that, sir? You understand there's an agreement between the attorneys that you receive there's no objection to 769 for a status, and there's a Killebrew agreement between the attorneys of no upfront jail. Do you understand that, sir? If I was not to follow that Killebrew agreement in regards to either one of those circumstances, you'd have the right to withdraw your plea. Do you understand that? All right. You've signed the bottom of the advice of rights. You understand that you have the right to trial. Is that correct?
Correct.
You understand that you have the right to counsel, and you have Mr. Abbott here who could cross-examine or contest any charges brought against you by the people of the state of Michigan.
Correct.
And you understand that you have the right not to testify against yourself and the right to silence. You understand that?
Right.
All right. With that understanding, you also, if your plea is accepted, you'll give up the right to indicate that the plea was anything other than what's been stated on the record. And you won't be having you'll give up the right to appeal any matter from a jury trial. Since you won't be having a jury trial, you'll be pleading guilty instead. Do you understand that, sir?
Correct.
Is it your wish today to waive your right to a jury trial and plead guilty in this matter?
Correct.
I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I'm going to bring your attention back to July 21st of 2024 at the offense location of 3005 Rio Road in the city of Lansing, Ingham County. Were you on that date, July 21st, 2024, at the Rio Road address?
Correct.
All right. And who is Amber Matthew to you?
That is my fiance.
All right. So you're in a somewhat dating relationship with her.
We've been together for like 17 years.
All right. Do you have a child in common?
Yeah, 3.
All right. So you are pleading guilty to the domestic violence count, which means that you offensively touched Miss Matthew, and this was not done in self-defense. So tell me what happened, and Mr. Abbott, feel free to ask any questions if you choose.
Thank you, Your Honor. On that day, that time, did you and Amber get into an argument?
Correct.
And at some point in that argument, you were in the kitchen
Correct.
and you shoved her.
Correct.
And also during this tussle, she ended up falling on the floor.
Correct.
And that was not done with her permission. Correct.
Correct.
And you did not do any of that in self-defense? Okay. Anything towards a factual basis, Ms. Wilson?
Briefly, Your Honor, Mr. Del Toro, you did this intentionally. This wasn't an accident.
It was not.
Okay. people are satisfied.
All right, anything towards the factual basis, Mr. Abbott?
No, thank you. That's
I find the factual basis to be knowing voluntarily and accurately made, and I will refer to probation. So go down to the 5th floor and set up, they'll either see you now or they'll get set an appointment. What they're gonna do is they're gonna do a report for me, and then we're gonna see what options are available to us, all right? So refer to probation, and date of sentencing would be, so October 4th at 8:30 for sentencing. On that time, we'll make a decision on the YTA status after the report's done.
769.
769 for A status. Yes. And the Killaroo no front jail. At this time, I don't know anything about the case. So once they report it to me and I'll get to review it, we'll see if I'm going to follow the recommendation. But I don't have any information to indicate that I wouldn't at this point. Okay, sir?
Yes, sir.
Anything else for the record in docket 2402160, Ms. Wilson?
Not for the people, thank you.
Mr. Abbott.
Yes, thank you, Your Honor. As he mentioned, the defendant and Ms. Matthew have children in common, children that he hasn't seen in several weeks. It's a month and a half until sentencing date. He'd like to have contact at least with his children, Your Honor. I'm not sure what the bond conditions are, but would it be
Right.
okay if they arrange through a third party to have parenting time?
Ms. Wilson.
Thank you, Your Honor. I have not specifically spoken with this, about this with the victim, but I do know that she said that the children do miss him and she wants him back in their life. So I will leave it to the court's discretion.
All right, so I think at this time, pending pretrial, we can modify the bond, bond condition, or at least explicitly, there's a no contact order, but it's not with the children, it is with Amber Matthew,
Correct.
the
So
victim in the matter.
if there's third party to
Correct.
arrange children visitation, I think that would be fine.
So we'll clarify that, and as long as there's third party adult supervision contact with children of defendant, and any supervision should be okayed by the complaining victim, which doesn't seem to be an issue, but I want to make sure that if there's a grandparent that is in dispute or a witness, we don't get that grandparent involved or anything like that. So any supervised conduct is to be okayed by the complaining victim. Mr. Del Toro, this is exactly the type of information that the pretrial service is going to talk to. They're going to talk to the complaining victim. They're going to get her side of the story. You are allowed to have supervised contact with your children by anybody okayed by the complaining victim in this matter, up until we come to a probation or we come to an order of judgment of sentence. All right, sir. All right, so we'll modify the bond to allow third-party contact with adult supervision with children. Anything else for the record of Mr. Abbott on 2402160?
No, thank you, Your Honor.
All right, so we'll modify it to that bond. Be as candid with them as possible in the probation interview, and then we'll see what options are available to us. All right, sir? All right, that's all for the record, 2402160. Thank you for your appearance today.
Thank you, Your Honor.
Thank you.
Then Ms. Wilson, I don't, what case did you want to go on? Rib house. All right, so we go on Robert Ribkowski. So we're on the record, docket 24-02065. That is People of the State of Michigan versus Robert Ribkowski. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Abbott representing Robert Rutkowski. He's standing to my right.
And sir, you are Robert Ribkowski, is that correct?
Yes, sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding this is going to be a plea to an added count 2 of or attempted criminal sexual conduct in the 4th degree. That would make it a 1-year misdemeanor or $250 with mandatory AIDS and STD testing.
Okay.
There is also a sentencing agreement to no further upfront jail.
Okay, so there's the Killebrew. So the attempt CSC 4th is a 1 year. What's that in the half of that of?
The attempt is a 1 year.
Okay, what's the fine? What's the fines and costs?
250.
250. So it's a 1 year and or $250. There's a Killebrew agreement of no upfront jail. Is that correct?
Correct, yes.
As a part of the plea, there is the possibility of the Sex Offender Registration Act and the STD testing and AIDS testing. Is that correct?
That's correct.
Is that, and then with a successful plea and sentence to count 2. Count 1 is to be dismissed. Is that right?
That's correct.
And is that a fair and accurate statement, Mr. Abbott?
Yes, it is, Your Honor.
Thank you. So may I inquire of your client the new charge and his advice? Do you have a advice of rights on this one? Thank you, Mr. Abbott. May I inquire of your client of his advice of rights on the plea to count 2?
Yes.
All right. So Mr. Ribkowski, you understand that there's an agreement that they're added count to an attempted CSC 4th. That is a 1 year and or $250 ultimate penalty. You understand that that's the request you'll be pleading to today, correct?
Yes, sir.
All right. With a plea to that, count 1 is to be dismissed. There is a Killebrew agreement, an agreement between the lawyers of no upfront jail time. If I was not to follow that agreement, you'd have the opportunity to withdraw your plea. Do you understand that?
Yes, sir.
So right now there's an agreement between the lawyers that you receive no more upfront jail. If I chose to go a different route, you'd get to withdraw your plea. So the lawyers are guaranteeing you that you get no upfront jail. You'd have the opportunity to withdraw your plea if I didn't follow that. Do you understand that?
Yes, sir.
Okay. There's also, it comes with an attempt CSC 4th that you'll be on the Sex Offender Registration Act. Do you understand that?
Yes, sir.
And that there may be mandatory AIDS or STD testing along with the attempt CSC 4th. Do you understand that, sir?
Yes, sir.
All right. With a successful plea to count 2, count 1 is to be dismissed. You've signed the bottom of this advice of rights form. Is that correct?
Yes, sir.
So you understand the 12 rights that are on the form. I'll go through the main rights with you. You understand that you'd be giving up the right to trial by jury today? You understand that?
Yes, sir.
You understand you'd have the right to counsel. Mr. Abbott is here to represent you and to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. And you'd be waiving that jury trial right in order to have this offer and plead guilty to count 2. You understand that Mr. Abbott is here and you have the right to counsel.
Yes, sir.
All right. You understand you have the right not to take the stand against yourself, and you also have the right to remain silent, and that silent can't be used against you at trial. Do you understand that, sir?
Yes, sir.
All right. With the advice of rights and the 12 rights that have been indicated, you understand that you'd be giving up the right to indicate that you're relying on something other than what's been stated on the record in regard to the plea. Do you understand that, sir? So we placed the plea agreement on the record. It would be, if you plead guilty today, you'd be indicating that you understand that what we placed on the record is the only reason you're pleading guilty, not some other reason. Okay. You also are not going to have a trial right today. So you won't have a trial, you'll be pleading guilty instead. So of course you can't appeal anything from trial since you'll be pleading guilty instead. Do you understand that, sir?
Yes, sir.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to January 1st, 2024, between January 1st, 2024 and January 21st, 2024, at the offense location of 535 North Dexter Drive in the city of Lansing, Ingham County. Were you present at the 535 North Dexter Drive, city of Lansing, Ingham County address on that date and time?
That's it was 536.
536.
Yeah,
All right.
536.
And that's in the city of Lansing, though?
Yes, sir.
All right. In Ingham County.
Yes, sir.
All right. And the charge is in count 2 of attempted CSC fourth. So Mr. Abbott, if you have any questions, but what is the factual basis? What happened on that date that makes you guilty of attempted CSC fourth?
Me and my stepdaughter were watching a movie while my stepson was at the foot of the bed, and she crawled up, cuddled me, and the way she was laying, my hand, I went to go rest my hand down, and it was on her butt, and it was more like a rubbing, coddling.
But Mr. Abbott, did you want to ask any questions?
Thank you. So you were, you put your hand on her bottom
Yes.
and it was on her skin,
No, it wasn't on skin, it was over pants.
on her pants? And you kept it there for, say, a minute or so?
Yeah, roughly, yes.
And it would be reasonable if someone else had been there watching, it would have been reasonable for them to think that it might have been for a sexual purpose? That you were, is that true?
Yes.
Ms. Wilson, the attempt CSC fourth would be the placing the hand on a part of the body that's covered by statute. The only thing I see is whether it was intentional or not. It appears that it was done for purposes that could be reasonably construed as sexual gratification, but any questions you have?
Yes, Your Honor, briefly. Mr. Rupkowski, did you touch the child's buttock intentionally?
Was this an accident or did you do it on purpose?
It wasn't intentional. It was just the way my arm, how she was laying on my arm, and I went to rest my arm down, and it was just.
Mr. Abbott, did you want some time to speak? Because if it was an accident,
Yeah,
then
we
we
don't have a
problem.
factual basis.
Can I ask a couple more questions?
You can.
But once your hand got there, you left it there on purpose, right?
Yes,
Okay.
All right.
Okay.
And Raylan is your stepdaughter,
that's correct.
and she's under 16 years old.
Yes,
All right. All right. So we have an intent in regards to leaving the hand there
Yeah.
and remaining. I will accept that as a factual basis.
If I could ask one more question.
You may.
Would you say that you accomplished this based on Raylan's surprise?
was that?
Was she surprised that you did this?
No, she was kind of like snuggling up saying, I love you, daddy, but there was nothing.
A little concerned about the
Well, I am too. I'm
here because I don't believe that the statute says 13 to 15. We don't have a child that's within that range. And then the other possibility is force or coercion, which could also be accomplished by surprise. So
right.
we need to have an additional factor
Be
there.
surprise, humiliation,
Yeah,
one of those
something.
aspects for the fourth, because this is an attempt for.
Yeah.
Well, Your Honor, I think that there's a size difference between the two. This is a young child and an adult male. There was a use of disadvantage of his size compared to hers.
Would the child, if would the age difference lend to the factual basis for the first? If the hand was remained on somebody under 12, and we can take it as attempt CSC fourth.
I would be satisfied with that.
Okay,
Yeah.
so the indication is that he touched the victim and the victim was 12 and under and was intentionally left on that, I think that would suffice for the count one,
Mhm.
and then count, that would
Yes,
suffice for count two, the attempt fourth.
yes.
So if you ask any questions concerning the age of the child, I think we should be fine.
I think we got that the child was under 12.
All right.
So I think if the factual basis is for the higher charge, I am satisfied for the factual basis for the attempt fourth.
Mr. Abbott, so that'd be your question. Would you accept that as the factual basis for count one?
First, Raylan was under 12 years old at the time.
Yes.
Okay. And I think that covers it.
Yeah, I also think that covers it. All right. So I'm going to take the factual basis for count one to count two, the attempt CSC fourth. And so I think that covers the factual basis in regards to count two. Are you satisfied for the factual basis for the attempt CSC fourth, Ms. Wilson?
I am, Your Honor. Thank you.
Mr. Abbott?
Yes, sir.
All right. I'm going to refer to probation. And sir, what they're going to do is they're going to ask you questions concerning these events, and they're going to prepare a report for me. And then we'll see what options are available for us at the report stage. It's at that time that I'll decide if we're going to follow the Killebrew upfront, no upfront jail, the decision, the agreement that was made between the lawyers. Okay.
Okay, yes, sir.
I don't know anything about the file, so I have no reason why I wouldn't follow it. All right. But that would be the time at sentencing that we would decide what the appropriate sentence is for you. So my response is be as candid with them as possible concerning these events. Okay.
Yes, sir.
Because I think that's key here. So we'll refer to probation. Refer to probation, and we'll set the sentencing date for
October 4th at 8:30.
October 4th at 8:30.
Yes.
There you have it. All right, so go down on the 5th floor to the probation department, and they're gonna prepare a report for you, and they'll prepare a report for me, and then I'll see on October 4th what options are available to us. And that'll be the sentencing date will be set for October 4th at 8:30. Anything else for the record in docket 24-02065, Ms. Wilson?
Not for the people.
Mr. Abbott?
Family contact.
Okay.
He's having no contact with his family at this point. Is it possible for him to have contact with members of the family other than Raylan? And maintain that relationship?
I have be not to be in the presence of minor children without adult supervision. No contact with a minor child. I would assume that's the complaining victim.
Yes.
So the request is that the adult supervision is needed for any minor contact with anybody other than the complaining victim. That would be the modification. So you're requesting a modification that they have unsupervised contact or just clarification?
Clarification. You don't have any contact. You get to see the kids.
I get to see Malachi once in a while, but I gotta have adult supervision.
Okay. And I guess clarification is.
All right, so in order, and it's completely fair. The only no contact order is in regards to the complaining victim in this matter. That's indicated. So you can continue to have contact with any other children in the matter as long as there's adult supervision, right? And that's how the pretrial condition is written. There is a GPS with exclusion zone concerning the minor child. We'll address that at sentencing, I think, because that we'll have to see what probation comes out with the sentencing in regard to the child and to any contact. Ms. Wilson, anything on modification or clarification of bond? This actually doesn't modify the bond, it just clarifies.
That was my question, because that's my understanding and reading the bond is that as long as it's not the complaining minor child, he can have contact with a minor child with other adults present.
With adult supervision.
Correct. So that's my understanding
Right.
in reading the bond.
So as long as your contact with anybody but the complaining victim is of a minor child is with adult supervision, you should be fine, all right?
Adult
And,
supervision means adult is there all the time.
right.
Yes.
Yes, yeah. And then we'll readdress that at sentencing once we get all the statements and we look at all the parameters and investigation done on the case, okay?
Yes.
All right, anything else for the record, Mr. Abbott?
Your Honor, I'd like to present the court a document I received from my client today from the Great Lakes Bay Health Center counseling.
All right, and that's
Be included in the file and considered in sentencing.
absolutely. Thank you, Mr. Abbott, and I will put that in the file for probation to review. And also to do any follow-up in regards, you might have to sign a waiver for probation in regards to Great Lake Bay so they can ask questions, but we'll put this in the file so they have it, okay?
Yes, sir.
All right,
Oh, yeah.
They can go further on.
thank you, Mr. Abbott. All right, you're all set, sir, and I will see you on October 4th, all right, sir?
Thanks so much, sir.
Thank you.
Freeman has Ricky on his case that's in circuit already, and he was in asking about it, about this one. I don't know if you want to talk to him about it. Okay, he just went that way. Well, the offer in circuit on his other file is some negotiation that includes 7411. Sarah's willing to package it with that.
Okay, 'cause that was.
That you did not know. I didn't know it either. And then I went into his other file and I was like, oh, that happened. That's good to know.
So let me know when you
Yeah.
want Dunick brought
I
up.
got a feeling we may not need your witness.
All right. All right, let me know when that, and then Mr. Goodrich, once we bring Dunick up, we'll bring Tomlin after,
Oh,
Thomas
yeah,
after that.
Thomas, yeah.
That's Mr. Goodrich's client.
All right. I'll be back.
All right.
as soon as possible.
Thank you, Mr. Abbott. So, Ms. Wilson, you have that witness here or on call?
No, I have one that's here and one that is not.
Okay.
I can definitely start with the
Right.
one I have
All
here.
right. Well, maybe it sounds like you might be able to package something up, so.
I hope so. He would be a dumb.
Well, if the prelim needs to be run, the prelim needs to be run.
Mhm.
And then Mr. Thomas can be brought up once we take Dunick down, I would think.
Yeah, I mean, if they're gonna need to talk to Zednick again, maybe, I don't know what. Mr. Goodrich
Maybe
is
talk
doing.
downstairs.
Yeah, I don't know if Mr. Goodrich is around, or if we even necessarily need to bring Thomas up, because I anticipate it's just gonna be a Nolly.
Okay. Oh, okay. So, and Mr. Goodrich is really good about
Yes,
talking to his
yes,
clients,
yeah.
so you let me know. All
Okay.
right. So on the last two,
Yeah,
and because Mr. Abbott might have stuff all over the.
I'm sure he does.
So. All right, now I'm gonna take a break. I'm gonna take a break, but I'm glad we got those two out. We were able to do a Del Toro and Rybowski. Would be interested to see what comes out of that probation violation pre-sentence on Rybowski. Because the way he was slanting it,
Yes.
if he continues that with the
And I
probation
knew
agent,
That's where.
we're
he
gonna
was
have a problem.
Go with it.
we're gonna have a problem.
And mom's not helping.
Yeah. Oh, I saw her.
Yeah.
I saw her, but it's probation's
Yep.
now.
Yep.
They're bailiwick now.
And
Yeah.
poor Jen Lawton has this case, and then she had a case set at the same time in 30th, and she was like, I need to know where I need to be. And so like
Yeah.
last minute yesterday, she's like, this is gonna be a plea, can you do it? And I was like, okay.
All right, so we're on the record in docket 24-02183. That's People, the State of Michigan versus Ricky Dunick. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Abbott standing next to Mr. Zdunik.
And sir, you are Ricky Zdunik?
Yes, that's correct.
All right, thank you. This is the time set for a preliminary examination. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe this is going to be an unconditional waiver from the defense. The people also unconditionally waived their right to a preliminary exam. Mr. Zdunik has a pending matter in 30th Circuit already. There's been an offer relayed on that matter. It's my understanding that the APA in that case is willing to incorporate this this offense into that offer. And I believe that's the offer that's being waived on.
All right. Is that your understanding, Mr. Abbott, that there's currently another case in circuit court, and this case will be incorporated in that current circuit court offer on the other file? Is that so? It's an unconditional waiver today.
Yes, and the offer in circuit court is 7411 status.
Okay.
Which we're interested in.
So I'm going to indicate that the negotiations are to continue, and there was an offer of 7411 status. Is that a fair statement, Ms. Wilson?
Yes, based on my review of the notes, typically it's no objection to 7411 if eligible, because sometimes probation gets a different report than we do. But my understanding is that 7411 was on the table. That's correct.
And that was on the other file.
That was on the other file that's already upstairs. Yes.
All right. Mr. Abbott may inquire of your client, Mr. Zdunik, of his waiver of the preliminary examination.
Yes.
So, Mr. Zdunik, you understand you have a right to a prelim today. The preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime has been committed and the identity of the individual who committed that crime. You are represented today by Attorney John Abbott, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding that there's currently a secondary file or another file in circuit court. So negotiations are going to continue, and part of the offer on that second file was that you achieve 7411 status on this file, and this file is going to be incorporated in that. Is that your understanding, sir?
Yes.
Is it your wish today and intent to waive your right to a preliminary examination today?
Yes.
And Ms. Wilson, you already indicated the people waived their right to a preliminary examination today. So I will provide counsel with the bind over documentation. Rarely do we have a race for the bind over documentation.
And she won.
I did.
Better look next time.
One, I'll just stand.
Well, you learn, I think. Just Slaviak just stayed out of the way.
Yeah.
I think that's the good move there.
Who says, you understand?
I get enough of it. So.
It's not the woman in white today.
You know,
That was funny. That was funny.
as I was getting dressed today, I was like, I'm gonna be the woman in black.
Which is a horror movie.
Yeah.
So I don't know that you want that.
No.
I don't know if you want either the woman in black or white, but as it turns out, it doesn't matter because they worked out. They were descriptive features.
May I approach your honor?
You may, Mr. Abbott. Thank you. All right, I'm in possession of the bind over documentation assigned by all the parties involved. I'll indicate that it has been waived on today's date. And before I sign the bind over documentation, anything else for the record in docket 24-62183, Ms. Wilson?
Not the people.
Mr. Abbott.
No, thank you.
All right, your time in district court is done, Mr. Zdunik. You'll be on to circuit court. You'll get your next date from Mr. Abbott in circuit court. All right, sir?
Okay, thank
All right, thank you. You're all set. Thank you for your appearance today. All right.
That's what the jail said for each file.
Your honor, could I inquire of the bond on this case?
Sure.
Please.
Let me look at the file real quick. The bond on this file is 5,000 cash surety.
Oh,
The court consider reducing bond, Your Honor. He's cooperating with the court. He's waiving his right to a preliminary examination. He's intending to negotiate a deal in circuit court. It's more than he can afford at this point.
I can only tell, I don't know what the bond was on the other file.
I don't know, because the bond on the other file, if this one was incorrect, I don't necessarily trust it online. I know, there's been a failure to appear on that file previously. And I think at this point, like, I understand that we just realized this after the court signed bind over, but I think technically the court has lost jurisdiction at this point.
I think so. And for the record, I would indicate there, the pretrial services indication is a fail to appear on 3 occasions. And that would, so this can be readdressed in circuit court.
Okay, thank you.
You're welcome. All right, so I will leave that. I've lost jurisdiction, but that can be readdressed in circuit court. That's all for the record in that file.
Get a pre-trial.
Now it's got those fail to appear.
Yeah.
That would have, even if I'd have thought about it ahead of time.
Right.
Yeah,
it wouldn't have worked.
It's a problem.
Yeah,
Yeah, in fact, I think that's why I didn't ask.
yeah.
That's good.
Well, that makes sense, but it doesn't hurt.
I think he has a plea date set for later this month, so he might be able to
Yeah.
do something
Right.
then, but.
Judge, I think my judge wanted to talk to you
Okay.
I'm
regarding
gonna go
tomorrow's stuff.
see Judge Craig.
Oh, fun.
Thank you, Your Honor.
Have fun, Mr. Abbott. Ms. Wilson, you're all set?
Yeah.
aren't you? All right.
See you tomorrow.
Okay. Yeah, whatever. I think we've got some stuff in the PCCs in the morning, some census.
Right,
And then some
but
wedding
because
stuff,
Judge
man.
DeLuca is gonna be covering our docket and your docket next week,
Yes.
for prelims. She doesn't wanna overwhelm him by having too many people. So normally,